Good afternoon. I'm Erwin Chemerinsky, and I'm incredibly fortunate the Dean of Berkeley Law. Welcome you to the beginning of the new school year. Our country is engaged in a long overdue reckoning with anti-Blackness and racism. Racism infects literally every aspect of the law. As a law school, it's incumbent upon us to study this and to make recommendations for change and reform. This is the sixth program in a series examining aspects of race in the law. It seems only appropriate on the first day of a new school year that we should be focusing on race and legal education. And that's what today's program is about. We have 7 wonderful speakers, faculty, and students to offer their views on this topic. I'm going to do a short introduction of each of them. I apologize that because of wanting to have time for their presentations, my introductions will not nearly begin to do justice to their credentials. And then they'll speak in this order. And in case you wondered the mystery of the order, it's simply alphabetical by first name. So the first speaker that we're going to hear from is Abbye Atkinson. She's an assistant professor of law at Berkeley Law. She's been part of our faculty since 2017. Second, we'll hear from Haney López. He's the Chief Justice Earl Warren Professor of Public Law. He's the director of the Racial Politics Program for the Haas Institute. The third speaker will be Kathy Abrams, the Herma Hill K Distinguished Professor of Law. She's been part of Berkeley Law since 2001. Our fourth speaker will be Kristin Alvarez. She's our Assistant Dean for Admissions and for Financial Aid, and also the chair of the Law School Admission Council's Diversity Program. She's been with us for over a dozen years at Berkeley Law. Our fifth speaker will be Ray Durham. He's a 2L here at Berkeley. Just a bit more about him. He's a graduate of the University of Louisville. He's an articles editor for both the California Law Review and the Berkeley Journal on African American Law and Policy. He's an advocate for the Post-Conviction Justice Project. He's co-president of SABLE, public interest chair of LASAD. Our sixth speaker will be Russell Robinson, who's the Walter Perry Johnson Professor of Law, and he's been part of Berkeley Law since 2011. And the final speaker will be Serena Nichols. She's a 3L here at Berkeley Law, got her undergraduate degree from Sacramento State. She's the former president of Law Students of African Descent at Berkeley Law, and she's in her second year as a co-editor of the Berkeley Journal on African American Law and Policy. My enormous thanks to each of these speakers for taking time to prepare these remarks and to present them today. And I said that each speaker will just get a bit under 10 minutes for their remarks. We're not going to then have time for questions and answers today, but this is just the first of our discussions about race and legal education. It's really our way of beginning the school year. So with that, I'll turn it over to my colleague, Abbye.
Thank you, Dean Chemerinsky. It's a pleasure to get to share a few thoughts on race and legal education with everyone today. I'd like to talk about the first-year curriculum and the erasure of race in the formal development of American legal doctrine. One of the challenges of legal education is the relative absence of discussions or acknowledgement of race in the formal development of the law. Race is usually relegated to a side conversation that ends with something like, okay, now let's get back to the cases or let's get back to the law. As a consequence, it can be very difficult to have the important discussions about race as it affects law in a formal sense in the classroom. Usually reactions that come from any attempt to have these discussions go something like, well, what does this have to do with the doctrine? This is a waste of time, or can we get back to the law? And it renders issues of race as mere diversions in the broader study of law. But race has played a significant role in the formal development of American legal doctrine. It is often central to the development of law, even if its presence is hidden from view by the choices of the judges that write opinions. When we do see race in the development of law, it is usually in areas of public law like constitutional law or criminal law, where it is, in my opinion, a necessary aspect of the discussion of how those particular areas of law have developed. but race is also integral to many aspects of private law, like contract law and tort law. Berkeley Law's own resident MacArthur Genius professor Dylan Penningroth has done compelling research on this very phenomenon. And I want to give you an example of the significance of race in the formal development of American private law from my own experience teaching 1L contracts. When discussing remedies to breach of contract, we read a case in my class called The Case of Mary Clark, a Woman of Color. It was decided by the Indiana Supreme Court in 1821. And the case comes before the court on a writ of habeas petition, it's a habeas petition. And with apologies to my colleague, Amanda Tyler, I'm going to try to, give you a quick summary of what that is. It's basically an attempt to ask the court to consider whether an individual's detention is unlawful. So G.W. Johnston brings Mary, a woman of color, that's what the case opinion tells us, to the lower court pursuant to a habeas writ that alleges that Johnston has been illegally detaining her. Johnston responds that Mary is in fact an indentured servant and that she's contracted to serve as a housemaid in his home for 20 years. His reasoning is that since Mary is a free woman and that she has freely signed a contract, there's nothing illegal about his insistence that she must stay in his home. The lower court agrees. Mary appeals to the state Supreme Court, and it's the state Supreme Court's opinion that appears in the casebook. The Indiana Supreme Court reverses the decision of the lower court, and it makes a few statements of fact, right? It says that as a factual matter, Mary's service is clearly involuntary. And it also tells us that slavery was illegal in Indiana at the time of the writing of this opinion. Moreover, we find out from the court that Indiana doesn't recognize indentured servitude contracts that are executed by African Americans outside of the bounds of Indiana. However, indentured servitude contracts that are executed in Indiana within the state boundaries are enforceable. So the court ultimately says this is just a question of garden variety contract dispute. Right? Mary, the court says, voluntarily entered into this indentured servitude contract while she was, in fact, in the state of Indiana. And so ultimately, the court decides the case, and the question in the case is whether she has breached the contract, which clearly she has, and then more specifically, whether as a remedy, the court will force her to perform the promise, which is to work for 20 years in the home of Mr. Jones. So we see many instances in this case of how race is actually shaping the formal structure of contract doctrine. For example, we can ask, why does Indiana make a legal distinction between indentured servitude contracts that are formed inside the boundaries versus those outside of the boundaries of the state? And ostensibly, it's because Indiana understands that enslaved persons that are brought across Indiana state lines might be forced to sign a indentured servitude contract once they arrive with their slave holders in the state of Indiana to try to give legal gloss to what is in effect a relationship of enslaved and enslaver. So we see race here playing a specific role, not just as a side discussion, but it's rooted in how this contract doctrine, this doctrine of specific performance is developing in the state of Indiana. Right, and in that regard, there's a much more significant aspect in which race plays a key role in the development of contract doctrine, at least within the jurisdiction of Indiana. Mary Clark's case is in the case book that I use in my class because it stands for the bright line rule in contract law about remedies for breach of contract, which is that there is no specific performance as remedy for the breach of a personal services contract. Specific performance, here's your contract lesson for the day. Specific performance is when the court activates its coercive powers to force the breaching party to perform their promise. Right, we see this most quintessentially, for example, in the sale of a house, right? If I a contract with the dean to sell my house to him, and I decide I don't want to, the court will force me to deed my property over as an appropriate remedy. But from this case, we understand that to the extent that the promise is one for personal services, specific performance is not available. And the reason why it's not available is because it looks like slavery, right? We no longer want to, at least nominally, force people to perform actions on the basis of contract doctrine that they have no desire to perform. And that's just one example, then, this Mary Clark case of how race plays a really important role, a significant role in the formal development of American law, and specifically American private law. Nevertheless, many contracts case books don't include cases like this. And many contracts case books would have you believe that race is not significant when we think about how the court might go about enforcing a set of private promises. And yet, if we understand as a practical matter that the relative position of any two individuals within society has great bearing on how they bind themselves to one another, and whether or not the court should enforce that promise, and then if so, how they should enforce that promise. In my opinion, in any case, it's hard pressed to understand how we might not think about issues of race, issues of inequality as informing how that doctrine has developed. So in sum, one area of opportunity for us as an institution, and then more generally all across legal education, as we evolve, hopefully evolve in our consideration of the impact of race in legal education, is to think about ways in which we can recognize, introduce, and analyze issues of race as central to the formal study of law, to the development of American legal doctrine, rather than treating race as a mere diversion from proper, so-called proper study of law. Thank you.
That's great, Abbye. I'm just going to go roll into my presentation. Thank you very much. That was super interesting. And thank you to Dean Chemerinsky for bringing us all together. My name is Ian Haney López. I want to start with a small fact, but I think it has tremendous significance. I've been teaching race and American law at Berkeley Law since 1995. In that time, in that quarter century, I can count on one hand the number of straight white men who've taken race and American law. Let me set that aside for 1 second, and then let me talk about the larger way in which we're structuring our conversation about race. And just think about the vocabulary. On one hand, we talk about anti-Blackness, or Black Lives Matter, or people of color. On the other hand, we talk about white privilege, white dominance, white supremacy, white fragility. And if you think about the opposition that's created by that vocabulary, it's an opposition that suggests that the basic conflict we face in society is one of racial hierarchy that puts whites and people of color in very different positions. And I'm presuming that most of you are nodding your heads and saying, yes, whites and people of color are in very different positions. I completely agree. But now I want to think through the implications of that in terms of the fight against racism. And one way to think about that implication is through the lens that Derek Bell offered us in the 1980s under the title of interest convergence. And what Bell said was partly analysis and partly prediction. As analysis, Derek Bell said, look, the truth is most whites benefit from racial privilege, and they rarely see their interests advanced by movements towards a racially egalitarian society. Some do, those swayed by moral arguments, most do not. So Bell said, when we see big advances in racial justice in the United States, it's often because there's a convergence between the interests of African Americans and the interests of a powerful segment of whites. And he uses that as a lens to explain the Civil War, and more particularly emancipation. He uses that to explain Brown versus Board of Education. So it's an analytic lens, but it's also a prediction, because Bell turns around and with interest convergence says, In effect, he anticipates an enduring reality in which whites continue to benefit from racism, continue to wield power in society, continue to be dominant in terms of class and status, positions of political authority, military authority, corporate authority. And that leads Bell in the 1980s to proclaim what he describes as the permanence of racism. So I want to start with interest convergence and say, I want to use an interest convergence lens, but I want to tell a different story, a story that particularly focuses on what has happened with race since the 1960s, since the civil rights movement. What has happened with race is that anti-Blackness has become a political project on behalf of the party formerly known as the Party of Big Business. The Republican Party, starting in 1964, and effectively continuing since then, and personified by Donald Trump today, is a party that is geared for the benefit of billionaires, that wins power on the basis of promoting racial division and racial conflict. And so this is a story that thinks about racism not primarily as a conflict between whites and people of color, though it's very much that, but as a phenomena that is supported by some of the most powerful actors in our country. One of our major political parties, the think tanks that are founded by people like the Koch brothers, funded by people like the Mercers, billionaire families like the Trumps. They provide, so racism out there, but the fuel for it, the fertilizer for it, the grow lights for it, they're coming from powerful elites who profit from division. And not just profit in this sort of status sort of way. If you think about what's happened since the late 1960s, we have had surging inequality, surging racial division, and levels of wealth inequality we haven't seen since prior to the New Deal. In effect, the economic redistribution of wealth outward of the New Deal has been undone over the last 50 years using race as the principal weapon, or in a more pithy formulation, in the class war, the rich are winning. Their principal weapon is racial division. And if that's right, and then you apply an interest convergence lens, you see that it is very much in the interest of whites to fight racism simply in order to take care of their own families, simply in order to redistribute wealth downward and outward, frankly, simply in order to have a government that during a pandemic actually averts mass death, rather than creating the situation in which Wall Street can have one of its most successful quarters on record, right? That's for whites. But also now think about it from the lens of people of color. And here I really want to talk for a moment about mass incarceration. So much energy right now is being driven by the systematic government violence against communities of color, and especially against African American communities. And the question is, what is the source of that violence? And very often when we ask that question, we hear an answer like that offered by the 1619 Project. The source of that violence is rooted in slavery. We see the answer provided in the title of Michelle Alexander's book. It's The New Jim Crow. Implicitly, mass incarceration is a sort of the consequences of centuries of racial oppression, and it is that. I completely agree. It is that, but that's not the proximate cause. The proximate cause of mass incarceration is politicians, Republicans, and then some Democrats, Bill Clinton in particular, who campaigned using themes of African Americans as a threat, as criminals, as dangerous, and then governed by building prisons and funding the police. And indeed, when you look at Michelle Alexander's book, she uses Jim Crow as a metaphor for the consequences of mass incarceration. But when she explains the origins of it, she talks about Ronald Reagan, George Bush, and Bill Clinton and dog whistle politics. And if dog whistling, if political elites sowing racial division as a route to power is the proximate source of mass incarceration, then defeating those politicians is the most immediate way to actually achieve major reforms in terms of incarceration, I would say in terms of mass deportation, mass surveillance. In other words, whether your interests are economic or environmental or built around racial justice, All of us have a shared agenda: defeat an elite political class that gains power by stoking racial division and then governs on behalf of corporations and the rich. And now let me just bring that back quickly to law school. If you want to think about what's happened to the federal judiciary, the rightward lurch of the federal judiciary is due very much to a politics of campaigning against a judiciary that promotes women's rights, that promotes gay rights, that promotes integration and racial justice, as an activist jury that is as an activist judiciary that's a threat to the country. That explains the sort of cultural politics of a lot of the appointments made to the Supreme Court, a lot of the appointments made to the federal bench, and yet this is the most pro-business judiciary the country has seen in over a century. And even more in terms of law school classrooms, we need an understanding of anti-Blackness in which it is seen as not just a threat to Black people, in which anti-Blackness is understood as the number one threat our society as a whole faces. All of our families are threatened by anti-Blackness. All of our families gain from a robust, meaningful commitment to racial justice. And I look forward to seeing more and more of you enrolled in race and American law. Oh, one last thing, raceclassacademy.com is a project I just launched to explain all these ideas in short, accessible video format, raceclassacademy.com.
I'm going to talk today about white faculty, specifically about the assumptions or tendencies among us that arise from our social and institutional privilege and reproduce racial inequality in law school settings. The patterns that I'm going to talk about don't focus on individual intentional racism. In my view, it's one of the big missteps of the legal system, as well as of mainstream political culture, to think of intentional racism as the paradigm. I'm going to focus on ways that white people, without meaning to do so, and often when we think we're helping, think or act in ways that harm or impede people of color. Two examples from this summer really captured this for me. The first came from the racial uprisings. White people did some valuable things in that context. We showed up against the police killings of people of color in ways that we haven't before. We signaled a willingness, at least for the moment, to be part of the work that needs to be done. That's all really important. But we also did some unproductive, even hurtful things. We repeatedly professed our commitment and allyship as if professing it conferred the understanding necessary to do it well. We became absorbed with our shame and guilt. We taxed the already raw emotions of our friends of color by sharing our newfound revelations, asking to be instructed about things we've already been told many times. In short, there was a surprising amount of focus on our feelings and our comfort in a moment that wasn't really about us. A second moment, much smaller but also revealing, came from a podcast called Nice White Parents. Some of you may know it. It's a great audio documentary about some white parents who decide to move their kids as a group into a public middle school in Brooklyn, previously attended almost exclusively by students of color. These parents were so confident that what was good for them and their kids was also good for the school, that they initiated a French language focus at a school where 30% of the students were native Spanish speakers and another 10% spoke Arabic at home. They established a fundraising relationship with the cultural arm of the French embassy without ever consulting with the school's longstanding PTA. Notably, this group confused its benefit with the larger good in an institution that it had not previously been part of, that was essentially somebody else's home. We as white educators act on some of these same tendencies to shape institutions to which we're not newcomers, but longtime inhabitants. It may be true differentially of us depending on our background, but race creates continuities that are reinforced by our position as faculty in the institutional hierarchy. We universalize from our own intuitions about what's valuable. We prioritize our own feelings and our own comfort. We think of racism, particularly when it implicates us, as a matter of intention. We value abstraction and dispassion. in talking about law and other things that matter. We respond with denial or deflection when we're challenged. These are patterns that arise from our privilege, from a world that has been constructed according to what we value and served over time to make us very comfortable. When we act on these tendencies in the law school setting, we produce unequal classrooms and unequal institutional labor. Some examples of how this works. Professor Atkinson's already explained how these patterns can affect what we teach. They also affect how we teach. They affect how we structure class exchanges, for example. In my class, I'm a big fan of wide open class discussions. Tee up a question or a juxtaposition and invite people to sort it out. I like this format because it can generate creative answers. I also like it because it's one I enjoyed as a law student. And if it worked for me, it must be fine for everyone, right? A number of years ago, a woman of color in one of my classes said to me, "Professor Abrams, do you notice who's talking when you tee up those big discussion questions?" And of course, she was right. Participants were disproportionately white and also frequently male. After that revelation, I made sure to call on people every day. But since then, if I'm honest, I think I've devoted more time to trying to make my classroom safe for open discussion than trying to learn how to use the Socratic method to help people feel a greater sense of confidence in the classroom. Tendencies that arise from white privilege can also affect what qualities we value in class discussion. Many professors favor a degree of abstraction in the classroom. Abstraction can be about what we draw from cases, focusing on the rule or the doctrinal pattern, not talking a lot about the people whose lives have been irrevocably changed by the conflicts that cases resolve. Abstraction can also mean how we expect students to talk about cases. Too much emotion, too much indignation on behalf of claimants whose cases are wrongly decided are often treated as a sign of incomplete legal socialization or of not understanding how the game is played. But as my colleagues Angela Harris and Marge Schultz wrote 20 years ago, the distance of abstraction is easy when the system is working well for you. Urgency or strong emotion, wanting to focus on lives disturbed or destroyed, that's much more likely when the status quo isn't working for you or for those whose lives resemble your own. The experience of race privilege also affects the way we respond when we get challenged or questioned about any of these practices. We may be defensive because we're not used to having our understanding of things challenged. We take refuge in our good intentions because that's the way we understand racism. We may be inclined to bury the whole incident because we want to see ourselves as getting it, sometimes more than we want to do the work of getting there. And we want to avoid the discomfort of seeing the limits of our own empathy or understanding. These tendencies create classrooms that work better for some students than for others. They create disparities in the extent to which students feel seen or valued, in how much risk they feel they're taking on when they speak, in how much institutional work they have to do in order to survive, let alone to thrive. These disparities are a real burden when people are trying to discover who they are as professionals. These same patterns can be true for faculty or staff of color in the larger law school environment. The challenge for us as white people, but particularly as faculty, is not to be reflexively led by these intuitions. It means slowing down to ask the kind of effects-based question that my student did. Not how do our choices intuitively feel for us, but how are they working for everyone in our classroom? It means having humility, realizing how much you don't know and how little we can infer about the lives of others, going solely on our own experience. It requires a willingness to educate ourselves, and God knows there are wonderful resources out there for doing that, but also to listen as undefensively as we can if somebody wants to help with the process along. But if there's any starting point to this, I think it might be a willingness to experience discomfort. Institutional structures, as we know them, are designed to make us feel comfortable. and changing them, acknowledging our implication or at least our benefit from these structures, doing the work that we've left to others in the past in partnership, but without substituting our judgment, knowing that given our incomplete understanding, we are going to make missteps along the way, sometimes really uncomfortable public ones. All of these are very uncomfortable. But in the sense that John Lewis talked about necessary trouble, a directive that I see as being for all of us, for white people, it may be that necessary discomfort is the first step on the path to change. Thanks.
Hello, good afternoon. Thank you so much. This has been wonderful so far. I'm Kristin Theis-Alvarez. I'm the Dean of Admissions and Financial Aid at the law school. And I'm really excited, frankly, that admissions and financial aid have been included in this conversation. I work at a somewhat unique, but still incredibly high stakes intersection of legal education, institutional policy, structures, and frankly, bureaucracies. And I do plan to speak today distinctly from that position. Broadly, I'll say this: there is an acute need for admissions and financial aid offices to examine critically our own policies and practices through an anti-racist lens. Getting good results, as we frequently congratulate ourselves about, does not mean that we are doing all that we can, should be, and must to understand persistent, systemic, and often invisible inequities in our processes and in our offices. And it certainly doesn't mean that we're doing anything at all to address those inequities. It's incumbent upon us to examine how being non-racist in admissions and financial aid is inadequate, wholly inadequate for our work, and to make changes proactively. What I mean by proactively, and I thank Professor Abrams for her conversation and that I accidentally alphabetically was able to follow her because I think that this somewhat flows from her remarks. So what I mean by proactively is with intention, rejecting a defensive posture, actively listening, not waiting to be called out on issues. And I would note that often that calling out happens by students who have themselves been burdened by the additional work of critically examining our office's practices, work that we should be doing. I also mean with a genuine willingness to make ourselves and hold ourselves accountable, but particularly accountable to people and entities that may not always be who we look to for validation of our efforts. It also has to be work that's done over the long term and not as a short-term reaction to a unique set of circumstances. I'm going to share a few examples of things that we could do in admissions and financial aid to sort of make this more concrete in no particular order. We should or could examine how our communications content and strategy is developed and what audiences we imagine and are speaking to. Well-intentioned, thoughtful, and really not at all racist admissions and financial aid professionals make choices all the time on things seemingly as insignificant as what articles to put on the website, when to use the word diversity and when to use a different language, what images we select for the view book. But it's often a white and at least somewhat progressive audience that is imagined and marketed towards. Whether the focus is conscious or not really makes no difference. That's an audience that often wants to see diversity and understand it as in terms of how it benefits them, but also doesn't want to be made uncomfortable. And so we frame, understand, and explain the value of racial diversity in law school to and for that audience in particular. We also need to look at how we ask racial and ethnic identity questions in the application itself, and moreover, the applicant's experience engaging with those questions. This past year, I was approached by a group of students from a Middle Eastern and North African student organization, frustrated, angry, upset about the fact that we listed Middle Eastern as a subcategory within white and Caucasian in our application. We worked with those students over at least 6 months and have made changes in the application for the upcoming year. I should note that when we review applications, this entire section is fully redacted because we can't consider race when making admissions decisions under Proposition 209 in California. But that doesn't mean that the applicant experience when completing this section is unimportant, or that the subsuming and erasure of some racial identities doesn't signify and express our institutional values. It also doesn't mean that we can't make changes and that we can't make ourselves open to learning how we can do better. I should note that understanding how we talk about the race of law students is important, but it's also problematic in an entirely different way because of external reporting requirements and data collection. For example, under the example that I just shared of Middle Eastern and North African students, while we've changed our application, it's worth noting that when reporting externally to the American Bar Association, those students will be counted as white. Additionally, individuals with multiple identities to the ABA will be reported as 2 or more races. Hispanics of any race will simply be Hispanics, and international students will be reported as non-resident aliens, regardless of race and regardless of their experience in this country as a Black, Indigenous, or other person of color. We need to problematize and be open to receiving critique of how we as admissions offices choose to frame our outcomes, often in the most positive to the institution and maybe even to ourselves, light possible, and how we actively avoid and ignore other ways that we might measure or represent our relative success. One thing I would note, just as a very specific example, is that we're very pleased, for example, that this year's class is about 14% Chicano and Latino. That's a significant number of individuals, and it shows a trajectory of inclusivity and engagement that's important. That all sounds fantastic. But another way of thinking about it is that in the state of California, the state in which this public institution exists, which is training attorneys to serve the public, the population is in fact closer to 39% Chicano or Latino. Right? So when I reframe that data point, it starts to look and feel somewhat different. It's not often how we choose to share that information, but again, we are making choices. Speaking specifically of financial aid, we need to look at our financial aid practices, particularly around the construction of merit as meaning and the deployment of resources based on that categorization and that language. Many schools have an extremely holistic application review process, but for practical purposes, and that I largely mean US News and World Report, frankly, switch to an extremely mechanical merit-based awarding system that privileges LSAT scores and grade point averages almost exclusively. Often in financial aid, we may award need-based aid, but we make an assumption that's invisible, that Black, Indigenous students of color are likely to demonstrate financial need, and that somehow being a Black and brown student also means that you are a poor or underprivileged student. I know from doing this for over a decade that that is not at all the case, even if you take into account many of the different ways that you might measure need. The combination of these two approaches is actually what's particularly problematic and interesting to me. When we don't consider someone meritorious, but we also don't consider them needy, we simply don't award them gift aid. And there is some data out there now that suggests that nationally there's an epidemic of disproportionately high student loan borrowing and indebtedness at graduation for Black, brown, and Indigenous law school graduates. Yet that data is rarely examined nor made visible in any way. It's certainly not demanded of us to share in any consumer or public information, and it's not something that we evaluate particularly critically. We also, and I think this is hopefully a good segue into some of the student speakers, need to be willing to engage with current students in a way that I think for us can sometimes feel uncomfortable. Admissions will often joke and say that one of the best things is that, you know, we have these relationships with students and then orientation happens and then we're done. If we're doing our jobs responsibly, our experience and our role cannot be bounded by the application at one end and orientation at the other end. From a practical standpoint, if we don't understand what the student experience is actually like in the classroom, in the community, amongst peers, when searching for a job, etc., we will get it wrong. And then that will backfire because we will say one thing and the students will tell other admitted students something else. The institution appears to be hiding something, and it's a look that will be not good and last a long time. In conclusion, I think there's a long list of things that we could work on, but frankly, the most encouraging part of this is that all of these things are fixable. They're mostly within our control. They're certainly within our ability to advocate for change, and we need to get started on that work.
Thank you, Dean Alvarez, and all of the other panelists. This has been great. As part of my discussion, I'm planning on talking about 3 different spaces in legal education and how they affect Black students and other students of color. First, I want to talk about employment. No doubt, many students of color come to law school to do work related to racial justice or some other public interest related work. Unfortunately, getting into a top 14 school usually requires taking on an enormous amount of debt. Very early on, students are forced to pick between which career route they will decide, and for some, there is no real choice. Along with crippling debt, the lack of financing given to students going into public interest is not sufficient to live on. $5,000 for 3 months is not enough to live on in any of the major cities Berkeley typically funnels its students to. This creates a situation where students who are going into public interest will have to either struggle financially or be supplemented through some other form of finance. Unfortunately, the latter is something that Black students and other students of color often lack, resulting in white students being a large majority of individuals who can go into public interest spaces in the first place. This result ensures that white students are the ones who are serving these communities and not the students of color who come from them. To address this pervasive issue, Berkeley should aggressively search for ways to fund public interest and encourage more workshops centered around navigating a career in the fields. Next, I want to talk about student groups. Affinity groups are necessary in legal education, especially at top institutions. Affinity groups like Law Students of African Descent and La Raza serve as havens for students to retreat to and be around people who have had similar lived experiences. The need for affinity groups shows up not only for current students, but for prospective students as well. The fact that Berkeley, for the past 3 years, has had an increase in the amount of Black students that have matriculated is no doubt partly the consequence of the efforts by the Law Students of African Descent to get other Black students here. Even acknowledging the fact that admissions efforts towards this end has played a huge part in this matriculation, the fact still remains that Black students are often used to get other Black students here. A personal anecdote serves to emphasize this. After I had gotten admitted to Berkeley, I received a booklet that was about 25 pages long, and the same Black student appeared 7 times. This emphasizes 2 facts. 1, Berkeley did not have a large group of Black students to choose from to put in their booklet. And 2, they needed a Black student in different sections of their booklet to emphasize diversity in a wide range of spaces. Unfortunately, the labor that goes into creating this community within affinity groups is a double-edged sword. Whereas Black students and students of color need this outlet to feel safe in law school, it also creates more labor for these students to create this space in the first place. This extra labor is particular to spaces for students of color. Students who are running these groups or even participating in these groups are necessarily at a disadvantage for at least 2 reasons. 1, these students have to choose between spending time within their group or spending time studying. And 2, these students have to choose between these affinity groups and other student organizations that fall within their interests. The result of these 2 disadvantages is the same. Students must choose between school-focused activities or being around their community. It goes without saying that this disadvantage is not one that white students have to deal with. There is a reason that there is no student group called Students of European Descent. And sure, there are student groups that white students fall into that may require more work. However, the ability to be a non-participant in these groups does not have the same implications that being a non-participant in affinity groups have. Berkeley should acknowledge this discrepancy and allow student leaders in these affinity groups to get extra credits or pay for their work or some other form of compensation. Finally, one of the longest lasting and most prestigious institutions in law school at Berkeley is the California Law Review. Last week, the masthead for the California Law Review came out. Out of over 60 people chosen, I was the only Black male offered a spot. Whether you pass this off as a result of low Black men matriculation into law school in the first place, or a low percentage of Black men finishing right on, the result is still shocking. This problem is not new or unique. Last year, there was still only 1 Black man who was a part of California Law Review or was accepted into California Law Review. The year before, the same thing. While this may be a symptom of racism that permeates through the legal system, it is a cause of many adverse effects. For instance, law review is often often one of the things that employers look at for when they're assessing an applicant. Law review is specifically important for clerkship applications. These positions are considered must for students at top 14 institutions. So low membership for Black students in these spaces necessarily means it will be more difficult for Black students to get these positions in the first place. Moreover, looking through the masthead and seeing my fellow journal members, I recognized individuals who had gotten on the journal who I had personally heard espouse racist or other oppressive language during my first year of law school. This emphasizes the fact that the term of diversity can be $1 million term while not actually doing anything to advance progressive thought or address the problems that exist in these spaces. In these spaces, the problem is anti-Blackness, transphobia, homophobia, sexism, ableism, and so on. Maintaining a positioning of diversity in order to address these problems is only the first of very small steps towards a more equitable space. CLR may be diverse on paper, but diversity does not mean anything if the same harm continues to exist. Berkeley Law can address these problems in CLR and so many other spaces by requiring a legal theories class for 1Ls. This legal theories class would include topics such as critical race theory, critical feminist theory, critical queer theory, and so on. The need for a class like this is long past due. Peer schools such as Georgetown, UCLA, UChicago, all have different programs emphasizing this extensive need for critical thought in their 1L curricula. Berkeley, as a leading institution in public interest among its peers and a school that touts its pro bono culture, should take the largest step yet by implementing these suggestions or suggestions like these to create a more equitable environment. Thank you.
Hello, it's good to see you all, and thank you for my fellow panelists for these powerful and compelling and really brave comments. I will try to fit in along these really powerful speakers. I'm going to talk a little bit about a law review article that I published in 2008 in the Columbia Law Review entitled Perceptual Segregation, and it argues that whites and Blacks are predisposed to disagree about racial discrimination because we have different incentives and information about race and racism. So most white people were raised to avoid thinking about or talking about race and racism, and this colorblind behavior, whites are taught makes them good, upstanding people. From the perspective of most Blacks, however, the failure to engage racism is a manifestation of white privilege. Black people have to engage race because failing to do so can be fatal. In order to avoid discrimination, we have to pay attention to race. Of course, one example of this that's relevant in this moment is the talk that most African-American parents have with their kids about police violence and the need to demonstrate respect for police officers in order to stay alive. Excuse me. White parents historically have not had to have this conversation with their children or any conversation about the privilege their kids have in avoiding that risk, unlike their Black friends. The killing of George Floyd by Minneapolis police has upended the racial order in surprising ways. For the first time in memory, whites are learning that being silent about race feeds racism and implicates them in the problem. As one slogan on the sign in my Oakland neighborhood says, white silence equals violence. Thus, many mainstream white people have expressed support for Black Lives Matter on social media and marched at protests, as Professor Abrams said. And in fact, according to some studies, the protesters in major cities such as New York were majority white. Yet this fresh eagerness to discuss race and confront racism carries new perils. And this is my topic today. After a lifetime of carefully avoiding race in order to appear non-racist, many white people, let's call them baby anti-racists, lack the education necessary to have this conversation. They may be ill-prepared to talk about race in a way that does not reproduce white privilege and aggravate their relationships with Black people and other people of color who are anti-racist. And I'm going to illustrate this with some examples from my life since the uprising. I've encountered at least a half dozen racially problematic encounters with well-meaning white people. And this task is an effort to turn lemons into lemonade and to give you all a frame, hopefully, for understanding some of your post-uprising experiences. So I invite you to consider whether you see yourself and where you see yourself in some of the scenarios that I'm about to describe. So the first main point is the challenge that we face in this moment. One of the challenges is that white people lack an education on race, but now feel compelled to address racism. So at the end of the first week of the racial uprising, I took a yoga class on Zoom. I am a big yogi, which means I'm typically in usually white female spaces. And so in this case, the teacher was a white man that I've known for years, and he began the class by acknowledging the uprising and how it was impacting people. At first, I was grateful, but that, well, at least he acknowledged the context, because a typical colorblind white move would be to just pretend as if race doesn't matter. The teacher stated that he had noticed that a lot of white people on social media were virtue signaling. So far, so good. I'd seen the same thing. But then he said, I've also noticed people getting angry and calling others racists. And he paused and flashed a knowing smile. But remember, calling someone a racist is just another form of othering. He then opened the floor for people to share any thoughts on their mind. Now, I found the othering comment to be triggering, and that is not a word that I use lightly, in its suggestion that calling out racism is actually a form of racism. That's what I heard him say. And this pain was aggravated by the majority white demographic of the class and the teacher's decision to open the floor for unstructured reflection. So for nearly 10 minutes, various white women expressed their shock at the Floyd killing and how upset they were about racism. There were white women tears, and their comments seemed to reflect an embryonic awareness of racism. By contrast, I felt that I had to tightly control my roiling emotions. I didn't feel that I had the right to express my outrage as to how white ignorance about racism, white narcissism, and white privilege were playing out in this very class. I stared out the window, I fixed my eyes on a tree and tried to practice that deep yoga breathing that they teach us all the time. And when the teacher finally brought the discussion to a close, I noticed that a full 15 minutes of the 1 hour class had elapsed and had been devoted to this unstructured conversation on race that I found excruciating. And I thought, I'm paying for this? I plucked this story from a yoga context because it's safe, but I fear that it is deeply relevant to Berkeley law and education more broadly. White professors, especially when they are teaching classes that they regard as irrelevant to race and racism, CEG Professor Atkinson's great talk, often avoid or minimize race when students bring it up. The racial uprising likely means that more white professors will try on their own to address race in their classes, and this may be for the first time in their lives. And it also means that social justice-oriented students who at Berkeley are not just students of color, but often white students as well, will insist on a race-conscious approach to law. Hopefully these professors did their homework over the summer and are ready, but I worry that some may make mistakes like my yoga teacher because of their lack of education on race and racism. Second, white-dominated institutions are likely to try to address racism by compelling their Black employees to provide additional uncompensated labor. The racial uprising created unprecedented pressure on institutions to demonstrate their solidarity with the Black Lives Matter movement and their commitment to anti-racism. So companies as diverse as Walmart, Levi's, even the gay porn studio Falcon Studios released statements endorsing Black Lives Matter. And I was sort of like, gay porn and Black Lives Matter, like, this is interesting. Many of these efforts felt frantic and lacking in deliberation. I smelled white desperation. On social media, many people called out the tension between the company's anti-racist statements and their histories of questionable and sometimes overtly racist labor practices. And then there was an intersection with my own life. So a friend who is a white gay man who created a startup reached out to me in June. And he texted, can I ask a big favor? He said that his company was planning to release a Black Lives Matter themed statement and asked if I would give him my thoughts before he released it. Note that this is different from the first scenario. Unlike my yoga teacher, this friend knew that he might not be fully aware of how a racially diverse audience would respond to this message and sought to vet it with his friend, a race scholar. So I give him credit for that. And he also recognized that he was asking a favor. But at the end of the day, it still led to a second problem. He created work for me. When I first read the statement, I knew in my gut it was wrong. But it took me several hours to process it and figure out how to tell him without upsetting him. Again, white comfort and white fragility is often in the mix here. I sent it to a mutual friend, a Black queer woman, to get her take on it. And so note now at least 3 levels of work that have happened. First, my time spent reading and analyzing the statement. Second, identifying a third party and asking her to share in that work. And I feel pretty bad that I did that, but I knew that she was his friend and that she cared about anti-racism. So I sort of spread the work around. And then third, I called the friend to discuss the problems with the statement. And I think she also texted him and echoed what I said. So we sort of, collaborated together. Now, to his credit, my friend got it immediately, did not try to defend himself. But as indicated by Professor Abrams, I think in many scenarios, there would be a fourth layer of work by the white person arguing with the person of color and saying, no, I didn't mean that. My intention, my heart was good. And then you, again, as the person of color, have to be in that role of comforting and telling them, I know you're good, don't worry, right? So we didn't have to do that dance, fortunately, with my friend. But I think in many cases, that is a key part of this. This incident also represents the intersection of friendship and employment. But another scenario involved a Black friend whose boss asked him to speak on a Zoom call for the whole company about race. And again, there's a difference here that, when it's friendship instead of employment, you can say no, but I knew that there'd be a cost if I said no to my friend's request, to the big favor. With my Black friend who was asked to speak on this panel, he didn't feel that he had the freedom to say no. Especially because he knew that the company was undergoing layoffs. And so there's a vulnerability, in this context when you're asked, will you speak on a panel with the CEO? He felt this was very risky because he had never met the CEO. He had no idea of his racial values or ideology. The company did not offer to give him the questions in advance. And he knew that he would have to walk a fine line between keeping it real and making the company look good, which, let's not forget, that is a part of a lot of these interventions. His boss either did not know or did not care about the pressure that he applied to this employee. I advised my friend to impose several conditions to his participation, and ultimately he was able to avoid the service because he said that the company found Blacks that were better at playing the game. So I tell this story to underscore the very real power dynamics operating when white-dominated institutions press into service their Black and other people of color employees in order to address racism. Moreover, when institutions decide to speak on race and demonstrate their anti-racism, there is a risk that they will compel Blacks and other people of color to do this additional labor without compensation or credit. Let me close with a real quick cheat sheet for white teachers addressing race in the class for the first time. And I welcome your feedback in terms of how this goes. So first of all, locate yourself.
Russell?
Yeah.
Can you finish up real quickly? Because I want to be sure we get to hear Serena. I apologize.
Got it. I'll be super quick. Locate yourself, own your identity position, acknowledge where you are in your process of becoming an anti-racist, acknowledge you might make mistakes, don't be defensive, and invite students to collaborate with you in making the class anti-racist. Thanks.
Thank you.
Hi, everyone. My name is Serena. I want to start by thanking the other panelists. I feel really honored to be a part of this discussion with all of you. And I'm really glad that it's a mix of students and admissions faculty and professors. I'd like to take some of my time at the beginning to say rest in peace to Breonna Taylor, George Floyd, Ahmaud Arbery, Elijah McClain, and Dominique Remy Fells. The tragedy of your deaths exemplifies the successes of white supremacy and transphobia in our world, and also the failure of those in power, including institutions like Berkeley Law, to reject those systems of harm and protect Black lives. I want to say thank you to all the Black law students who have been advocating all summer long and for most of their lives on these issues. And I hope that you can continue to do so with limited harm to your own selves. Today, my topic is experiencing the 1L curriculum as a Black woman and as a first-generation professional student. Many students like me experience having aspects of our identity reduced to single units in the syllabus, if they're mentioned at all. This unfortunately feeds into my first larger point, which is imposter syndrome. The most prominent part of my 1L experience was feeling like imposter syndrome and like I didn't belong in the classroom, like Kristin was going to email me and say there was an issue with my application and I really needed to leave. And this was exacerbated by the erasure of social contexts such as race, gender, and class in the study of law. This is especially harmful because when arriving at law school, students of color are already at a disadvantage by feeling like they don't belong there. And this feeling of not belonging can sometimes be due to stark differences in class privilege among students, and also from low numbers of Black students and faculty at large, which is an issue that's also exacerbated by problems with colorism that privilege light-skinned Black students within our community on campus. Many students of color are motivated to attend law school based on unjust or violent experiences with the law, or from curiosity formed from years of questioning why people like us remain disadvantaged by the law. And then when we arrive at school, we're confronted with being told to learn the doctrine first. We'll get to your experiences later. In class, students occasionally opt into discussions of race and gender, and the erasure of these topics from the curriculum forces students of color to bring them up themselves, which puts us in the unique position of taking away from class time that non-marginalized students see as their own. These experiences of being on the outside during the first year can be incredibly stressful in students of color. Having a unit on race in a doctrinal class is not the same as integrating critical race theory into the curriculum. And it's not a single law, and there's not a single law class that isn't affected by the study of race or gender. These feelings of isolation and missing conversation leave students of color with the burden of becoming gap fillers. So in class, students of color do the work of bringing up essential context of race, gender, or class that often gets left out. Often, this is done for legal cases we've just read the night before. Our role in the class discussion is invaluable, yet the cost is so high because it can expose vulnerability in a way that is often punished in the legal profession. As one of my good friends put it, a lot of white students don't deserve to hear our pain displayed in the classroom. Outside the classroom, the extra work students of color do often goes unacknowledged, unappreciated, and uncompensated. Or worse, it's just expected of students of color to do this extra labor. We're developing discussion groups to supplement class material. Students develop creative outlets such as blogs or podcasts, which one of my friends and I did. Or they're hosting our monologues, which is put on by the Women of Color Collective to talk about issues of their identity and the law. We're joining committees, we're running programs for students of color that ultimately benefit all students. And we spend hours upon hours recruiting faculty and students to our campus. Our payment, as Ray alluded to, is getting our picture taken for brochures and then going home later than our white peers so we can get started on the work for class that they've already spent hours doing. I think it's clear we have a long way to go to make race and legal education a valued and respected intersection of study and experience. And I'm looking forward to continued commitments from the university to making this a top priority.
Thank you. We're just about at the end of time, so I think what I'm going to do is express my enormous thanks to each of the panelists for their insightful, their eloquent, and their important comments. As they point out, there is so much work that we need to do as an institution individually, and we must do it. We're going to continue this series next week with a panel of law students talking about student activism against racism. I hope very much that you'll join with us next week for that. Please take care, be healthy and safe, and I hope that it's a wonderful semester for all who are watching and for all of us. Thank you again so much to the panelists.